Alrighty. Yeah, now it's working. I had gone live, but I don't think it worked. Anyway, nothing's happened yet. This is the Lane Myers status conference hearing held at Pima County Superior Court. I'm streaming all the hearings that I can in an effort to promote transparency in government. It's been 7 minutes. We're just waiting for the hearing to start. Hopefully they're just running late and not forgot to have it be streamed audio-wise. They've denied media requests. They even denied the ability to have a personal recorder. So this is literally the only record that the public has access to. Well, we've been waiting 10 minutes now. The hearing is still not started. I think most of the hearings have started on time before now, so. I had this channel open all day just so I could hear, just in case anything happened early, and it was literally just silent the whole day. No other court cases were being live streamed at all today. It would be nice if they all were. I would really enjoy that, but they don't seem to like transparency too much. But all we can do is watch and wait and hope that they start the hearing. It's already kind of late in the day, so there's not going to be much time to cover a lot of things. I watch a lot of different auditors, and I first found out about Lane Myers through This Is a Public Service, and also I think another channel called Dark Times with Nico and Sai. They also are covering this story, so I highly recommend those channels to catch up on the whole history, because I've just kind of been replaying the hearings just to get multiple copies of that out into the world, basically. I'm gonna watch them anyway, so I might as well rebroadcast it too. I definitely hope to cover the trial in June or July. I think it's July. Been waiting for 13 minutes for the hearing to begin. Still nothing. 16 minutes since the hearing should have started. And still nothing. As you can see, it's courtroom 687. 20 people watching the live stream from 22. The way I find out about these hearings, or at least verify them, is through the... Oh, no, I don't want to do that. My bad. Oh. I hear audio. We're about to start.
State of Arizona versus Lane Jeffrey Myers, CR 2025-1060 and CR 2025-1454. This is a status conference regarding the upcoming trial. As to both matters, parties' appearances will start with the state.
Rachel Stiles for the state, and the victim is present.
Lane Myers.
Okay.
On behalf of myself.
All right. And great. So when we were last here on the newer case number, we had set trial for July 21st, which I have to move to the 22nd because my trial start date is on a Tuesday. And then we consolidated the cases but hadn't confirmed the trial date as to the first matter. And Mr. Myers, you said you were going to file a motion to remove me for cause.
Yeah, well, what happened is that they still didn't, so, you know, I'm supposed to get envelopes when I request them, so I went back to the jail thinking I was gonna have an envelope waiting for me to send the motion in, and I just got the envelope on Friday, so it's kinda hard to do anything when you request these envelopes like they said I can request, and it takes, I requested it on the 17th. They confirmed I would get an envelope the morning of the hearing, that's why I was like, oh, when I get back, I'm gonna file it, and then they finally gave me the envelope, what was that, the 9th? May 9th, so it was hard to do it within 10 days. But I have a bond motion that I just filed.
Okay, I want to talk about the trial date because that's what we're here for. Ms. Stiles, I take it you still want to set them together and starting on July 22nd?
Yes, Your Honor.
All right, so I'm going to move the trial date from the 21st to the 22nd because the 22nd is my start date, 10:30 a.m., and that's as to both CR numbers are consolidated for purposes of trial. And we're still, I have that set as a 1 week. Well, Mr. Resnick, I understand that works with your schedule too.
I'm looking right now, Judge. The 22nd of July?
Yeah.
Does that leave enough time for sentencing within the speedy trial?
Sentencing, it's only if you're convicted.
Well, it's still gotta be within the speedy trial.
No, it's just when the trial starts.
Well, you have to be sentenced within the 150 days. That's case law. That's Supreme Court case law.
All right, you can file a motion on that. Mr. Resnick?
Free the 22nd.
Okay, so trials started on the 22nd at 10:30 a.m. And let's see if we have a status conference right before that.
Let me see what I've been doing.
Yeah, let's set a final status conference the week before. So we'll have a status conference on Monday, July 14th. And again, it is a firm trial date. I'll extend it based on extraordinary circumstances. If either side files motions, please secure hearing time for my judicial assistant. And the deadlines are those set forth the rules of criminal procedure. All right. And did we address the questionnaire before?
No, the Mr. Johnson, I mean, not Mr. Johnson, what was his name? McDonald, right? The judge that when you were missing.
Right.
Of course, I didn't find out about it till I got this big file from Parvin the other day. When he was here and we did the first July 21st, he said something about he wanted it within 60 days or something, the questionnaire, you know? And I just found out that out like last Wednesday. But he said that on what, April 15th? So nobody even informed me of that until I read it myself in the minute.
The question is, do you want to use the jury questionnaire?
And Your Honor, we're not asking for a questionnaire.
Okay. Mr. Resnick, would you want to advise him? Yes. Okay. Well, yeah, let's do it on morning calendar.
But it might give you more time. I consider which jurors you want, which jurors you don't. But if you want one, there's a time frame, you have to request it. So,
The 60 days.
yeah.
Okay. So are you asking, do I want to do it?
Do you want a questionnaire?
Yes.
Okay. So defendant having requested a questionnaire, proposed questions we do on June 5th.
And Your Honor, can I just raise one issue with that?
Yes.
My concern for having a questionnaire in this case is if they learn that if we're putting any questions in there that alert people that to his name and that it's a social media type case, that essentially what they'll go do is they will go look. And I think because everything is online in this case, that we run the risk that to the jury pool, which is why I would have concerns about a questionnaire in this particular case.
Mr. Myers, your response?
Even the case law, like, so if we reverse that, I would not be able to, like, I've read the case law about child publicity and all that. I would not be able to claim prejudice if people saw it on the news because if it's on the news, it is what it is. And I've read all the case law about, because I was looking at, can I change the trial to a different county and all this because people might know about my channel and all this. And the law is clear, like, they need to prove prejudice. They can't just request it. They can do that in a motion later or something because unless they can show for sure that their case is being prejudiced, just the fact that it's on the news isn't enough prejudice, and it's not even on the news. It's my own channel, so it's like.
Well, I think there's a higher risk, not just on the news, but they could go to your channel. Your channel's publicly available, I take it.
Yeah, because it's First Amendment, like they have the right, but there's nothing stopping them from doing that anyways once they know that they're my juror on the day 2 of the case. After the first day, they could go and read it, which I'm going to encourage them to do.
Yeah, you can't do that.
Well, I'm gonna.
And this
Well,
just,
Mr. Myers, you can't do that.
Well, I'm gonna.
Well,
I'm gonna tell them
not
to
going to
like,
let
share,
you,
and
hold on.
subscribe.
I'm not going to let you represent yourself if you start talking like that.
Okay, I get what
You can't. One of the main rules of a trial is you can't go to the event location. And that's kind of what this is. So, for example, let's say that it was a shooting in a parking lot. The jurors can't go to that parking lot and look at where the shooting
They're not
was.
supposed to do research, I know.
Correct.
I know.
And that would include looking at your channel.
Would that include you reading the transcript of the grand jury to do the slap motion when it's not part of the record?
That has nothing to do with what the jury hears. They wouldn't.
Well, you're only supposed to stick to the facts in the record too.
I did.
No, the grand jury transcript's not part of the record.
It is.
You told me it's not.
No, I didn't say that. I said I normally don't get it. But remember, you reminded me, and I had requested it to read it in that case.
so
It is
you-
part of the record. If you're convicted and it goes to the Court of Appeals, the transcript is part of what goes to the Court of
Because I
Appeals.
thought there was no independent fact finding.
I didn't, it's part of the record.
I'm saying for the jury either, you're saying also. You're saying the jury could go to my channel and independent fact find.
No, they can't. That's what I'm saying. They
The
cannot.
concern is, I'm saying the concern that we're addressing right now that she brought up is that they could do that. There's a
If they
possibility.
know about your case, right.
Well, I'm gonna make sure they do, because I'm gonna put billboards up around town.
All right.
And Your Honor, just to further that, it's not just about Mr. Myers's page, it's also because there's a lot of other people on YouTube, both for and against Mr. Myers. And so I would be concerned that they would go not just find information in support of him, but that they could find negative information where when they come in and they're actually in front of the court admonishes them that they're not allowed to go look for that information, where they may not realize that they're not allowed to look for it, just getting the information ahead of time in a questionnaire.
I don't feel prejudiced. I don't see why they would either. They should
Hold
want
on,
people doing
hold on
honest
just a minute, Mr. Myers. Let me look at the rule on case-specific written questionnaires. So the first sentence of Rule 18.5C, unless the court orders otherwise, so I can order that there's no questionnaire. I think I'm going to follow that in this case. I am concerned about if they know about the case, that they might do research, not knowing that they're not supposed to do research. So I'm going to deny the request for a questionnaire in this case. There's no motion pending before me on pretrial publicity. There's no gag order in place.
So no questionnaire?
No questionnaire. I'm concerned about Mr. Myers' threat to try to publicize this case. What's the state's position on that?
Your Honor, I hadn't been concerned about that since Mr. Myers, because there was early on, we had discussed the fact that he was doing the live streams from the jail, and that was a concern. And then he agreed to not be doing that, which, as far as I know, he's abided by that. He has not been doing that. So I would hope if the court just advises him not to engage in that behavior, that he would be willing to follow that. But I do have concerns with him raising it now, saying that he wants to do that. I will note that we've been engaged and we've started a discussion of settling the case. And I can tell you that that would definitely have ramifications if he's doing things to harm his case with that. But
Harm the case, not probably harming his case.
That's what I'm saying. So that's what I mean.
Hold on.
It's not, it's, there's two sides to this.
I guess what the state is saying, if you start engaging in that behavior, they'd be less willing to try to offer you a plea.
We already went over this rule 3.6, child publicity. I can talk about my case publicly. There's nothing you can do to stop me from.
I can definitely issue a gag order.
Well, then do it.
Well, I don't want to do that if I don't have to.
And that's what I'm saying. So it's either there's a gag order or I can talk about my case publicly.
Your Honor, and when I'm referencing that, I'm referencing more of the things where if he's engaging in the same type of behavior that got him here today, that led to these criminal charges, if that started up again, that would then interfere with
That's directed towards the victims.
Right.
Correct.
Right.
Yes. So that's where I would be concerned if he's doing things like that, that's causing further harm.
That's a crime.
To the victim in this case, then that would obviously impede settlement. If he's just doing things that's trying to harm if there's things that he's doing that seems to be interfering with his making sure there's a fair trial in this case with undue pretrial publicity, where then we're going to have difficulty finding a fair jury either for the state or for Mr. Myers, then I think we have other issues that are concerning, because like I said, the information that's out there in the public right now is not just all supportive of Mr. Myers. He also has, a camp that's also against Mr. Myers, and I want to make sure that we're not getting where we have a jury pool that's being influenced improperly by, any type of publicity on the social media that's happening, that we're going to have difficulties with that. So I'm concerned.
Are the police informed of that information if there's some reason to believe that he would be trying to do something to taint the jury pool, that you would be made aware of that and you could file a motion at that time?
So we do different things where he gets monitored to make sure, and then obviously because he's laughing about that. But as far as like you know, the people that are involved with YouTubers, we know what's happening with their channels. The channels are being monitored. He's in jail. He has limited privacy. And so things like that are monitored. We're not sitting there listening to it day in, day out, because we have other things to do with our lives. But it is something that we're looking into. So if, you know, he's making indications he's going to be doing that, obviously we'll be paying attention to that more to make sure that that's not happening. And if we get a concern like that, then I will file something with the court to raise it to the court's attention.
Right, so I think we'll stick with the current orders that Mr. Myers should not engage in conduct towards the victim that could be considered harassing. If you engage in pretrial publicity to try to taint the jury pool, the state can file a motion. We'll address it at that time. Okay.
That's what I wanted. I think it got misconstrued what I was saying. I'm not gonna be doing anything towards the victim. That's a crime. And I'm talking about why can't I do an interview with K-Gun 9 and put myself on the news? I'm the one that has to weigh the pretrial publicity, prejudicing myself. And do you hear them saying that there's people that are against me? So are you going to gag order them? No, you're going to so I can't talk about my case in a positive or in a way that I feel representative of the case, but the people that are against me could make videos and taint the jury pool. And I'm glad you didn't put the, I'm not, like you said, take the win, but I mean, let's keep the record here. So she wants to, I can say, but she has no control over the negative publicity against me, which would then harm me and harm the jury pool and all that, which they would be perfectly fine with.
Right, so I'm not issuing any orders right now.
Thank you, appreciate it.
I'm just limited to what we talked about before, you're not engaged.
So can we clearly delineate what you're saying here? Because, it kind of got twisted around. I said I'm going to put up billboards about going to my channel, but that's for publicity, to get views, to get money off the views, off the videos, to pay for commissary and, legal fees and stuff, which is my right. Now, what I think she turned that into was me trying to harm the jury pool or something. Well, not everybody's going to see it. And most of all, why would I not be allowed to talk about my case? If anything, they should be glad that I talk about my case, because then I might incriminate myself.
So, Mr. Myers, I'm not going to issue any orders on that today.
So I'm allowed to talk about it?
I'm not.
I don't want to do something that is wrong. You get what I'm trying to say?
I can't set down a bunch of rules as to what's allowed and not without knowing the context. So
I don't want to break any rule. That's what I'm trying to say, is I want to stay within the bounds of fair play, for lack of a better term.
yeah,
And so I want to make sure that because I'm the type of person that I need clear, you know what I mean? Clear.
I would suggest that you talk to Mr. Resnick maybe
Okay.
about that, what you think is acceptable. I'm not trying to put you off, Mr. Myers. I just don't want to prejudge the matter without a record before me, and it'd be too hard, I think, to try to set a bunch of rules on that. Mr. Resnick?
Just so I understand it, Judge, if the court's saying that he is retaining his First Amendment rights to talk about the case, he cannot talk about the victim. And I guess perhaps what we could do is, if Mr. Myers has some content that he is worried about, we could come to the court and say, here's what he's planning on doing, and we can run it by, and you guys can decide whether or not it runs afoul of the
And he
First
mentioned,
Amendment. Maybe
this before,
that'll
Mr. Resnick, you were on the case, that he did mention the rules on pretrial publicity, the rules of professional conduct, and there are rules in there that you can correct misinformation and do certain things. That's why I don't want to prejudge this, because
Fair enough.
I couldn't think of every scenario, and I would make a mistake if I did that.
Fair enough. So I think what Mr. Myers will do, if I understand Lane correctly, is he'll put his stuff together, and if there's content that's questionable, we'll run it by the court first.
Yes.
Okay, great.
Thank you, sir.
Okay. Anything else we need to address today?
The bond motion, set a hearing within 7 days. Re-examination. And the victim thing doesn't come into it because they had the last one within 3 days. But even so, then that's next Monday, Tuesday, or Wednesday.
I thought we did have a hearing before.
No, Harvin filed a motion. You were supposed to give us a re-examination hearing within 7 days. Somehow it turned into this convoluted, the state got to respond, you had to do research. That's not how this works. This is a procedural, procedural thing. This isn't a dispositive motion. You file the motion under Rule 7.4C when it gets transferred to a new court, which it clearly has. And then the standard of review, as you can see in here, I've included all the relevant case law, which Parvin's motion was trash, so it kind of took you guys out in the left field. You turned 1 + 1 into quantum physics, but let's get back to 1 + 1. 1 + 1 is case was transferred, Rule 7.4C, re-examination, bail eligibility. When you're not eligible for bail as a matter of a right, that means that you have to get the full evidentiary hearing to get afforded due process. That controlling case law is Seguro versus Condone. And from Dominguez versus Metcalf, you know that you have to interpret the rules in the plain language. And the plain language is when the case is transferred, you get a bail re-examination hearing, and you guys are questioning, oh, we don't want to go over Miller's shoulder and all that. Well, actually, that's exactly what you're required to do because it's supposed to be de novo. That's Mendez versus Robertson. The standard of review for re-examination, the plain meaning of re-examination is renew.
Oh, slow down.
Oh, slow down. I thought you said sit down. Sorry. And so, I got it all right here, all the controlling case law. It's very clear that I should have already had a hearing within 7 days. But, now's the chance to do it all over again and show that you're going to follow the law and give me my due process because this has already been taken to this appeals court and Supreme Court. And
Okay, let me, hold on.
2007.
Mr. Myers, hold on. Mr. Myers.
Yep.
At the hearing on April 21st, I had taken that motion under advisement, but then your lawyer withdrew it.
Yeah, no, I know, I'm not, and that's what I'm saying. I'm conceding that, I'm saying both sides of it. Like,
Okay.
Initially, when it was filed, you should have just immediately, it's like kind of like not a 10.1, but a 10.2 when you change as a matter of right. It's like, it's a motion, but it's really like a notice, but it's worded as a motion, but it's like the state doesn't get to respond.
Okay.
And so what I'm trying to say is like in a 10.2 as a matter of right motion, I filed the defendant, either party files the rule 10.2 and it's boom, it's a matter of procedure. The motion gets filed, the wheels start turning. This is the same with the re-examine bail eligibility pursuant to 7.4C. Because and the quickest way to determine that is the court can do it on its own. So it doesn't need to be fully briefed because if the court did it on its own, neither party would get to brief anyways. And so it's a procedural thing. It's you could have, and so I'm not trying to say both sides here. Like, I'm not trying to criticize you because like I said, when it was initially filed, you could only, the parties are supposed to give you a roadmap. You're the judge. We give you the roadmap to the destination. And Parvin's motion didn't. He took you way out in the left field, which then took Rachel way out in the left, even way farther out in the left field, which then had you scratching your head going, what are we even talking about here? I need to go review it more and that kind of thing. Well, I just want to get back to basics. The rules of procedure are very, very clear. 7.4C, on motion or its own, the court may re-examine bail eligibility. When you're not eligible for bail as a matter of right, that means you have to get the full evidentiary hearing every time to get due process. That's not for everybody, because if you're not bailable as a matter of right, if you're bailable as a matter of right, it's a modification hearing. It's a modify the conditions of release because you're bailable as a matter of right, so we're just going to modify. When you're not bailable as a matter of right, you're determining eligibility of bail. So you have to examine whether I'm eligible or not, which there's a limited, 4 or 5 reasons, sexual conduct, the reasons. But then there's also the felony one. And so because I'm not bailable, because, at the initial appearance, I was found to not be bailable as a matter of right. Mm-hmm. That means then to then review that when I'm transferred to another court, the standard of that review is de novo, because re-examine means, renew again. The court is found. Supreme Court of Arizona and the Court of Appeals has upheld this many times. And then when you're not bailable as a matter of right, what is the procedure? Oh, it's re-examine means bail eligibility. Well, we need to, each time you look at it, well, I only get one if it's transferred. This is my one chance. So you need to hold that evidentiary hearing again. It's not the same as the modification thing where the state would have you doing evidentiary hearings every time somebody wanted to take it from 250 to 200, that kind of thing. this is a very limited set of circumstances which require the full evidentiary hearing and the state to prove their burden. And furthermore, the charges that I was arrested on initially in the initial bail eligibility, well, one of those the grand jury found was a misdemeanor. So now it's those two that we had with Miller and a different one that is felony that they indicted me on. So that felony, that third felony of that, it was only 2 at the first. Now that we'd have to re-examine, and you need to find, determine if there's proof evident on a new charge that wasn't included in that hearing, which is even more of a reason it needs to be a full evidentiary hearing. But I don't need to argue for it to be, it's statutorily, not statutory, but procedurally, and there's controlling case law, because after 2007, they clarified that, because the Federal Bail Reform Act, there's, I have it all in here. It's not really up for debate. It's just set the hearing within 7 days, and the only debate is, do you find proof evident or not?
So the 7 days I see under 7.4C3, but that's
Yeah.
when the motion's filed by the state.
No, it's not. You got to read the case law. Don't just gaslight me and not read my motion. I have it right in here where there's 2 case laws. See, you're doing it again, the same thing you did in Dominguez versus Martinez. You're making up your own version of the rules of procedure. And the court told you to follow the rules as they're written. And if you read the controlling case law, Seguro versus Canunan, it's right in front of your face, sitting on the desk. My motion tells you, Rule 7.4 was amended to read essentially as in the proposed rules, providing that a motion involving
Slow down.
whether a defendant shall be held without bail shall be held on the record as soon as practicable, but not later than 7 days after the filing of the motion. And then it goes again, right here, to the extent Simpson holds that due process requires a hearing at which the defendant has the right to counsel and the right to cross-examine and offer evidence, reaffirm its holding. That was in 2007, or 2008, after it was modified in 2007. The stuff that Ms. Stiles and Parvin were arguing were before 2007, and now there's a plain reading now. It's not if a state files a motion. It's bail eligibility hearings have to be held within 7 days. The Rule 3 says if the state files it, they need not allege new facts. You're putting it all together, but it's not surplusage. It's the same thing you did before when you said that transferred into a court and new material facts. That's not the rule. The relevant part of 7.4 provides that any person remaining in custody may move for re-examination of the conditions of release whenever the case is transferred to a different court. That's Mendez versus Robertson. That's the Court of Appeals clarifying it's not when it's transferred and the allegation of new material facts. It's when it's transferred or the material facts. And that's right here, included in the motion. It's axiomatic that when a court is asked to re-examine release conditions, the review must be de novo. Rule 7.4 requires the respondent judge to examine anew the conditions. Moreover, both situations in which a court may re-examine a release order, a transfer to a new court, or new information appear in the same sentence of the rule, providing 2 instances in which the court may look at the order anew. We don't believe the Supreme Court intended different standards of review to be applied to the 2 circumstances listed in this rule. And then it continues in that, in R.E. Maricopa County, they quote that in Mendez v. Robinson. Division 1 of this court held that the transfer of a juvenile to Superior Court for prosecution as adult is a transfer to a different court. So a transfer to a different court in and of itself triggers the re-examination of bail eligibility. And because I'm not bailable as a matter of right, that's the only time you use the word bail eligibility is when somebody's not eligible for bail. You're determining if I'm eligible or not. Otherwise, you're just modifying the conditions. And that's where that whole thing got confusing. Can I look over Miller's shoulder and stuff? You're required to look. Not only can you, but you're required to, because you're required to do a de novo review. And because I'm not eligible, it needs to be a full evidentiary hearing where I can cross-examine witnesses and present evidence, and the state has to meet their burden of proof evident. And that's clear as day in this case law. And I don't know, like I said, I know Parvin's motion was a little bit wonky, and you needed, but somehow it got to the point where we're 31 days after a bail eligibility motion was filed, and I still haven't had my hearing. So 7 days, I mean, why would it need to be 7 days when all the rule says 7 days? The case law says 7 days. You're looking at the rule of procedure, but the case law says 7 days. Must be, and they remanded when it wasn't within 7 days. So I don't understand the confusion about it being within 7 days. It's literally a hearing de novo within 7 days because I'm not eligible as a matter of right.
Okay.
So I don't know why it keeps getting twisted just for me. And I mean, if you don't do it, it's misconduct at this point because you're blatantly disregarding the law.
So, Ms. Stiles, I would intend to set this Friday since the victims are here and they would have actual notice. I could set it on Friday afternoon.
So, Your Honor, first of all, we already argued this motion.
Right, but we argued it, and then I took it under advisement, and then Mr. Parvin withdrew it, so I didn't issue a ruling. And
Yes, but we're still in the same, so what are you asking to set another hearing so we can argue it again?
No, proof evident.
Because he's not entitled to a new, that was the whole point, is he's
No,
not
I am.
entitled. Would you let
I
me
am.
speak,
don't
please?
interrupt. Don't interrupt. Go ahead, Ms. Stiles.
He's not entitled to have another review. He cited zero case law or anything that says he's entitled to have another hearing on no bond. It's not happened. It doesn't happen. There's no case law supporting it. Under the Arizona Constitution, it's clear that once that finding is made, he is not eligible for bail. And under Rule 7.2, he is not eligible. It's not a discretionary thing for the court. Once that finding is made, it is a mandatory thing that the proof's to be held without bond.
Right, but 7.4C1 says on motion or on its own, a court may re-examine bail eligibility. So right now he's determined not bail eligible.
And if you go down a little bit to refer to the thing in I think it's maybe 4 or 5, the definition of 7.2 initially, and that's why it's all in my motion if you just pick it up and read it. I've laid it out like a little map for grade school level. The 7.2 initially is only because you got to remember when I'm brought to court, right? I'm given my initial appearance. I still haven't even been charged with a felony at that point. I'm still, under the 10-day preliminary or I need to be indicted period. So the initial 7.2 finding, that's why it says until further order, because it says that if the magistrate finds you at the initial appearance, he goes, that the first test is probable cause that I committed a felony while on bond for a felony. Boom. That sets the first bail eligibility hearing where if they find you the proof evident or presumption great until further order, because that's not indefinite because you still have not even been charged with the felony. You've only been found that there's presumption or proof of a felony, and then you still have to get the preliminary hearing and actually be charged with the felony, or there's a supervening indictment and it's transferred to superior court, and that's what the first finding under 7.2B1B holds you while they get you formally charged with the felony. Then once you're formally charged, that's why the reading of 7.21 says until further order. And guess what? Further order is it's transferred to a new court, and then the court re-examines bail eligibility and has to find the proof evident again. And that's where she's really confused, and I'm trying to be polite about it, but this is really elementary level stuff, and I'm not trying to diminish her or condemn, be condescending, but it's did you read
Well, she hasn't read it. You just filed it today.
No, but I'm saying it's like she's a prosecutor with 14 years experience. This is literally a matter of routine in every other court except this one apparently. But the reason you have to read the plain language. It says right. Until further order. Okay. And then it gives the condition of when you can get a further order. And that's where we're at. Set the hearing, please.
Hold on. So you're criticizing everybody.
I'm trying not to criticize. I'm not slick with I don't have a huge vocabulary, and most of my things I say are very direct. Okay. I'm trying to say in a polite way that I clearly have a right to have this re-examined. Don't tell me I didn't include case law because the case law is right there, and she's the one telling me I got access to the law library. And now that I used it and proved what I'm trying to say, now suddenly it can't be both.
Okay, Mr. Myers, when it was filed before, I did have a hearing, and I was going to read all that stuff, but then your lawyer withdrew it. So
because
don't criticize.
Because I feel
so
he made it way too confusing.
Okay.
Let's just get back to basics. The rule says re-examine. And if I wasn't eligible, why would it say that the court even on its own could do it?
Okay, so, but you're criticizing everybody.
trying not to criticize.
But
I'm
we
try-
set,
I'm trying to
I
preface
understand.
what I'm saying by saying, don't take this as criticism. I just speak very directly.
but you have to recall, I set a hearing and I was going to read all this
Thank you.
stuff. But then your lawyer said that he was withdrawing that.
Because
So
I
now,
didn't want him to argue it.
all right, now we're resetting this. And I'm inclined to set a hearing on
Thank you.
Friday. I have a trial next week, so I can't do it next week.
Thank
and
you, sir.
My law and motion day is filled up. So, I think we can argue what the standard review is on his motion for, to review release conditions.
It's not, that's the nomenclature. The legal nomenclature is re-examine bail eligibility.
Correct.
And when you take the nomenclature into modify release conditions, then you get away with, well, we don't need a hearing because we're just modifying the conditions. When you're re-examining bail eligibility, it has to be an evidentiary hearing where the state needs to provide proof evident, or not the state, but the state needs to present and you need to find.
Okay.
Proof evident or presumption great, which you
Ms.
want.
Alves, I'm inclined to set a hearing on Friday afternoon. We can argue this after I've read all the case law.
And Your Honor, the victim's not available Friday, and that was my next question was, well, the problem, I think we have,
When would work
do we
better?
have a hearing Friday morning already in here?
I have,
Oh, that was the old one.
um,
I mean, she's available that morning.
I have my morning calendar on Friday. We could do it like,
So if we could do, like, I don't know, if you have available at like 10:30 or 11.
let's see how big my day is on Friday.
And I'm gonna need that, their disclosure ahead of the hearing.
I don't have a particularly big calendar on Friday. I only have two sentencing, so we could probably do it at 10:30 in the morning on Friday.
10:30 would be fine.
Okay. So we'll start the hearing 10:30 on Friday. And Mr. Myers, if we get into something where we do need to take evidence, it may go beyond that, but
Oh,
I
I know,
can't.
the last one went over.
Well,
yeah.
I'll go to noon. We're not going to do it in the afternoon.
I'm saying the last one took 2 days because we
Yeah.
got, right.
I just want to be clear. I think Mr. Myers is thinking that we're having a no bond hearing on Friday.
We are.
We're going to argue about whether you're entitled to it.
No, I'm entitled to it and we need to have the hearing within 7 days.
We're having a hearing within 7 days, but it's not going to end within 7 days.
We're having the evidentiary hearing on Friday.
We're going to argue on Friday whether is a right to an evidentiary
No,
hearing.
we're arguing that right now.
No, because I haven't read your stuff yet.
There's nothing you need to read. It's if I request it, you give it to me. It's that simple. It's literally a matter of procedure.
I'm not going to be threatened like that.
It's not threatening, it's literally read the rule.
All right. So we're going to hit.
I'm not doing this again, sir. You have to recuse yourself.
No, I'm not.
No, I'm serious. If you're not going to follow the law, you have to recuse yourself.
I'm
I'm not doing this with you.
all right. Now you're starting to get angry.
No, you're blatantly disregarding the law. and
You
violating
filed
the
this.
code. It's
Listen.
it's a procedural thing.
So,
I
Mr.
filed
Myers,
the motion,
Mr. Myers,
set
hold-
the hearing.
Mr. Myers, you filed a motion. I haven't been able to read it yet. I'm setting a hearing on Friday, okay? And I'll have a chance to read all of this and read the cases. I don't know if you're right or not. You're saying that you're just you want me to assume that you're right. That's not the way the
I want you to
adversarial
read
process.
I want you to read the rule of procedures and interpret them plainly.
Okay, I'm setting a hearing on Friday.
What are you going to do on Friday? We're going to
We're-
argue whether I get a hearing or not?
Yes.
No, that's not the procedure.
Okay.
That's a violation of the Code of Judicial Conduct.
All right. You could file a complaint then.
Oh, you're going to get a lot of them.
All right.
So you're saying that we're not having the bail eligibility hearing within 7 days?
We're gonna argue about whether you're entitled.
No, there's
to
no
one.
arguing.
All right. We're going around in circles. I already said with the hearing.
When is the bail reexamination evidentiary hearing?
We got to see if you're entitled to one.
I'm entitled to one as a matter of right.
We're going in circles. All right.
No, you're doing this again, the same thing you did to Parvin.
We're going to have a hearing Friday at 10:30.
The
I'll have
evidentiary
read-
hearing.
No, I'll have read all your stuff. I'll have read the cases, and I'll tell you
So
whether
we're
you're
going to have
entitled.
the hearing on Monday, Tuesday, or Wednesday.
I have a trial next week.
Well, then how are we going to have it within 7 days?
Mr. Myers, we're going to come back.
No, you're going to follow the law or you're going to get off this case.
No, I don't like the threats. It's not helping your case.
Is that a threat?
You're
You're threatening me now.
No, you're threatening me. You're telling me if I don't do what you
I'm
want,
telling you, you need to follow the law.
okay, and I need to read what it is.
You don't know the law?
I don't know all these cases. I don't have every case
It's not
memorized.
case law, it's the rule of procedure.
We're done here. We'll see you Friday at 10:30 a.m. All right? Until then, we're adjourned.
No,
You're
no, no,
excused.
no, 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 no. I'm not coming on to Friday. I'm not.
Wow. Well, it's quite an interesting hearing there. I don't know, man. Sometimes I think the judge is gonna do the right thing, and then he turns around and does something like that. And it's like, what? But I'll be covering the not evidentiary hearing on Friday the 16th at 10:30 a.m. Arizona time, 12:30 Texas time. And then it'll be a hearing to see if he can have a hearing. Anyway, thanks for watching. Like and subscribe. I'll be back on Friday the 16th. Bye.